Hi, everyone, and welcome to our webinar, Countdown to HIPAA Enforcement Date, the checklist of last steps for complying with new HIPAA regulations. I am not Briar Andreessen or Katie Ilton. I'm David Glazer, and I'm crashing this real quickly because I wanted to do a couple of quick announcements and do quick introductions of them as well. So first off, we're trying something new. In the past, everyone who signed up for one of these webinars would get a little CD of the webinar afterwards. We're not doing that. Instead, there's going to be a new method. You still get the webinar, but there's a website called SlideShare, which allows streaming, basically real time, exactly what you're experiencing right now, but you would be doing it on SlideShare. And so in the next couple of days, this webinar will be posted, and already many of our past webinars are posted there. And so you'll be able to go back and watch this over and over again. Or more practically, you can forward it to anyone in your organization. If you think it's worthwhile, you can click on the link and send it on. Just like this webinar, it's free, totally free. So you can share this or other webinars with anyone you want. There's currently a little bit of a hiccup if you use Internet Explorer. If it's difficult to get it into full screen, the trick for that is if you click on the name below the presentation, that can put it into full screen, and that hiccup is supposed to get fixed by the SlideShare people shortly. But if you wanted to learn, for example, how to do rack appeals, Katie and I did a talk on practical tips for rack appeals. That webinar is on the site right now. We'll be emailing you out a link to that to get you there. And speaking of Katie Ilton and rack appeals, if you're looking for a really efficient way to do a rack appeal, I would have to recommend you use Katie for that. She's teaching people how to fish so that you can do the rack appeals internally without using outside consultants on this stuff. So that's a cheap and easy way to do it. All right. Our other administrative issues are upcoming webinars. So on August 14th, we're going to do pricing, which will cover things like discounts, out-of-network discounts, all the issues related to healthcare pricing. That has, until today, often been our biggest webinar. Those of you who saw that on Monday, the new fee schedule, or proposed fee schedule, and an inpatient proposed rule came out, which could dramatically change the way Medicare reimburses people for care. It's only a proposed rule, but we'll talk a little bit about that as part of kind of the pricing webinar on August 14th. Then in September, probably Briar and Katie will be back, but the topic is going to be HIPAA training, and we'll do a webinar that you can use to train your staff about HIPAA. They'll talk more about that. But I'll just comment, I had a client who was telling me how much they were spending on HIPAA training the other day, and I thought, why do that if you can use Briar and Katie to do the same training way cheaper? You can even use it with a targeted webinar or something, and not even, you can have them on site, but have them off site and do the same thing. All right, so let's get on to this. I used to give advice about confidentiality back in the old days. I thought I knew a lot about it. I still feel comfortable doing investigations, but when it comes to actual HIPAA stuff, it's too darn complicated now. And so when I have a HIPAA question, I turn to the experts who are here right now, Briar and Katie. Briar is such an expert that actually a bunch of insurance companies have not only put her on the panel as their go-to person for HIPAA, but a few of them have named her as the exclusive counsel that they will use in HIPAA things. And it's a thing to keep in mind. If you get a HIPAA issue, you may have insurance that will cover your disclosure. So something to keep in mind.
Oh, thanks, David. You just stepped on one of my important talking points.
I stepped probably in it, Briar, didn't I? Mm-hmm. Okay, and so the last thing I'll say is Briar is an expert because her initials are BAA. So with that, here's Briar, who will actually talk about real HIPAA stuff.
Thank you, David. I have one very quick administrative thing. If you downloaded or printed out the slides before today, there are actually 2 new ones in there, so you should either print them out again or just pay attention later on, and I'll try and remember to let you know what the new things are.
And then also I'll say, if you have questions, there's a box at the bottom right-hand corner of your screen. We'll try to get to those at the end, and if we don't, then we'll try to get to you after.
So, moving on with the actual stuff here. Oh, I'm sorry, we're having technical difficulties. There we go. Sorry. So first is the mandatory scare tactic at the beginning. The overview of what's been going on. And as you know, we do have new rules and we're waiting for them to go into effect, but there is still ongoing enforcement. And so every once in a while we will see a settlement come down from OCR, the Office for Civil Rights. And some of the recent ones that are out there are kind of interesting. The first one listed is Shasta Regional Medical Center, and this one is interesting because it's one of the first that I've seen that involves the executives of the organization getting the organization in trouble. And they got a $275,000 fine, and essentially it's because the kind of higher level executives talked with newspapers and the media to try and defend themselves against a billing allegation. And in doing this, they provided the patient's information without the patient's authorization to the media, and also in an email to hundreds of the organization's employees. So that was a major mistake and resulted in a $275,000 settlement amount. Another one recent is the Idaho State University. They got a $400,000 fine. One big feature of that one was that they had not done a risk analysis for their ePHI, which is their electronic PHI. And that you will see is a recurring theme. Hospice of Northern Idaho was a small fine, only $50,000, but it was an interesting one because that was the first time that there was a settlement amount for a case that involved fewer than 500 people. And that one too was a lost laptop. One huge fine was for Massachusetts Eye. That was another lost laptop, and one thing that OCR noted in their press release about this is that the organization had demonstrated a long-term organizational disregard for the requirements of the security rule. And basically, that meant that the covered entity had just ignored it and hadn't done anything, hadn't taken any steps to deal with that. So that's another recurring theme here is the risk analysis and risk assessment and security rule compliance. Those are actually big deals. They've been ignored for quite a while, but they are important. One thing that we have not seen yet is a settlement related specifically to a business associate. We think that is going to be coming down the road. And in fact, business associates are the source of quite a bit of risk to covered entities. One case that has made national headlines that we worked on was the Accretive case. And in that case, Accretive was doing some kind of financial work for a couple of hospitals, and one of their employees had a laptop stolen from his car, and it had PHI of 2 hospitals, and so the hospitals were involved. And our work on that case on behalf of one of the hospitals was really similar to the work that we would have to do for a covered entity that had itself had a breach. There was a ton of fallout from that one, Attorney General investigation, shakeups at the hospitals as a result. So if your business associate messes up, it can be a big deal. We have missed a slide in here, I think. There was a slide, hopefully, that was talking about what to do when there is an investigation. And so when OCR comes, what they will actually do, thank you, Katie, they will come not knocking at your door most of the time. They will actually write a letter. And so this OCR letter that kind of sets out the very basics of what happened is the start of most investigations. Sometimes there will be a sort of a courtesy phone call saying, a violation's been reported to us, you're going to be getting a letter. That does not always happen. Very often it's just that letter that shows up. The letter usually requests documents, requests that you explain what happened if you think that it wasn't a violation. It will request often some of your policies, a risk assessment, and follow-up is not uncommon. So you'll send them all your stuff, and then I would say in probably maybe 85% of cases, OCR will come back with something that says, please send us this and this and this, or please provide additional explanation on this and that. It doesn't mean that there's going to be a problem, it just means that you have to keep dealing with it. The very good news is that most of these investigations are closed without any fines or settlements. Sometimes the worst that you will have is OCR will make you change some policies or do some training or something else. So most of the time you can get out of it without too much damage. But that doesn't mean, even if you are able to escape a monetary settlement, it doesn't mean that you won't have to expend a lot of time and money dealing with the situation. So obviously, best to avoid this proactively if you can. And then when something happens, you want to either be indemnified for it or try and keep costs down to the extent that you can. So, what to do? First thing, if you get a letter, find out if you do have coverage. David mentioned the insurance, that many insurers do have coverage for this, so check with your insurer. And if you don't know or if you don't yet have coverage, ask about it and find out if you can get additional coverage for that. Then contact a lawyer. I would say in many cases it is helpful to have legal counsel with this, especially somebody who has dealt with OCR before and knows what they're looking for and knows what makes them mad. Gather up your facts and documents and policies. Find out from the people who were actually involved what happened. Was there a good explanation for why this happened? And then send the requested information. Ask for an extension if you need one. They will tell you have 30 days from the date of the letter to respond, and some investigators, every one of them has a different style. Some of them have been pretty easygoing in these investigations. Some have been very, very difficult to deal with. And it's kind of just luck of the draw what you get. So, but it never hurts to ask for an extension if you need one and say, we'll send you what we've got right now, but we're still investigating X, Y, and Z. And then wait. In many cases, we have to wait quite a while to hear anything from OCR, even if they're just going to close the case. And in some cases, we're still waiting for official word, even a couple of years later. They have a backlog right now that they're dealing with, and so it makes some sense that they're taking a while, but it just kind of is, it could be sitting out there for quite a while. So important dates. The effective date of the new rules was March 26th, so they are effective as of right now, but the compliance date is not until September 23rd, 2013. And in the title, we promised that there's a countdown, so here it is. You have 75 days from now to the compliance date. One caveat to that is the compliance date for having updated business associate agreements and data use agreements. If they were in effect prior to January 25th, 2013, which is when the final rule came out, then you are okay to not update them until September 22nd of 2014. And now I will hand it over to Katie.
Thank you, Briar. So many of you were probably with us in February when we did our first pass on a webinar through these new HIPAA regulations. And a lot of what you're going to hear today is similar content, but what we've tried to do is make this as practical as possible. And so the way we're going to move through the rest of the webinar is to talk first about all of the policies that you have, hopefully, currently, that do need to be changed by September and what exactly needs to be changed in those policies. And then we'll also talk about some forms that you would have, the business associate form, notice of privacy practice, authorization, and what needs to change in those forms. And then at the end, we'll talk a bit about some of the common issues that we see from clients that are leading to OCR investigations. So that's how we're going to go about the rest of this talk. So just a few words generally about HIPAA policies. Sometimes we lawyers will say that if you're not going to follow a policy, then you maybe don't even want to have one. That's not the case for HIPAA. HIPAA actually requires all covered entities to have privacy and security rule policies. Business associates must also have security rule policies. Business associates might not technically under the rule have to have privacy policies, but in many cases, business associates are doing privacy rule things for covered entities. And so it would definitely make sense to have an internal policy explaining to the business associates workforce how in the world to comply. So you have to have policies. You should have them now. And you also have to update the policies when the law changes.
And if I could just break in for a moment, I meant to mention earlier but forgot, and this does have to do with policies. You need to make sure that your state law is reflected in your policies and your forms. And unfortunately, we can't discuss the state law today. I'm not positive if we have all 50 states, but we definitely are covering all of the time zones, so there is a lot of variation that we just cannot get to. But HIPAA does require you to have your state law that applies in your policies, and your people in the organization should know what laws they need to comply with. And also, if your organization operates in more than one state, you need to have each of the states reflected.
One way to ask for a fine from OCR is to have them do an investigation, and when they ask for your policies, not be able to send them anything because you don't have them. So while many OCR negotiations and investigations end up without a fine, it's not going to be a good start if you can't turn over some sort of policies. And in these investigations, OCR will actually read and critique your policies, so you want to start out with some good solid ones. On the same note, the training of the workforce is another area that absolutely must be addressed under HIPAA. Covered entities, business associates, where applicable, have to train You have to train your workforce. Your workforce doesn't consist just of your employees, but includes volunteers and anybody else who's under your direct control. One thing we see happens with clients a lot is that they give somebody a really brief HIPAA training session when they're hired, and then they don't do it again for multiple years afterwards, and then that person is involved in a HIPAA breach, or maybe it just comes up that they haven't done training for a while. So train periodically. And one way we're going to help you do that is in September, David mentioned, we're going to have a training webinar that you can actually sit your workforce in front of and listen to, and we will be talking directly to the workforce on what HIPAA is and what they should know about it. The other plug I'll make is that if you feel like training should be more customized because you're a big organization, you have a different sort of operations than the traditional covered entity, we can do HIPAA training webinars that are customized just for you. They're pretty inexpensive, especially compared to some of the consultant fees I've seen, and so don't be afraid to ask us tell us how we can help you train your workforce. The other thing I'll say about training is make sure you document when people get the training, because you might have to produce that. It might help you make your case in an OCR investigation that you've actually done some training, that someone should have known that they were put on notice, that you did your best as a covered entity. This will help. So document training dates because you might get asked for them. So what policies should you have now? On the next two slides, we have actually a screenshot of what are in the template policies that our health law group has developed to sell to covered entities and business associates. We'll have a link at the end of the webinar that explains how we can get those. They're, I think, relatively inexpensive, but this is the list that we've developed of what a covered entity should have in its policies. It's not a magic list. I think it's fairly comprehensive. It's organized in a manner that we think makes sense. But if you look at these, you can get an idea of what you should include. You might not necessarily need all of these policies. For example, at the end of the slide, there's research, marketing, fundraising. If you don't do any of that, then I don't think you need a policy on it. But certainly, as a general rule, if you're a covered entity and there's a rule in HIPAA that talks about something that you actually do, you should have a policy on it. And then I'll just mention at the end of this slide, on the second screenshot of the policies, there's a list of forms that you should have. You definitely need the Notice of Privacy Practice. You need the Business Associate Agreement. You might not need some of these other smaller forms that deal with some of the privacy rule pieces, but we found that they're helpful and practical to clients in implementing these policies. So we encourage you to take a look at those. Briar mentioned, really important to incorporate state law. It's required by HIPAA. Also, when policies change, you have to train accordingly. Don't wait until the next training date, whether that's 2 or 3 years down the road. If somebody's job is affected by how a policy has changed, then that person should be trained when it changes. All right, so this is kind of our list of the policies that have where the regulations have changed, and so you'll need to actually go through and change your policies. And we've basically done everything short of writing the policies out on the slides. So in the next few slides, when we're talking about policies, what the content on these slides is basically the new information and the stuff that needs to change in your policies. So let's start with individual access to PHI. This concerns the right of an individual to ask for a copy or to inspect their PHI. A couple things have changed here. The first is that a covered entity now only has 30 days to provide that access. Before it was the 60-day rule. You can ask for an extension or you can give an extension, but I think the general rule should be try to get it done within the 30 days. The other biggie in this area is that now it is required that if a covered entity actually maintains PHI in electronic form, and an individual asks for a copy in the electronic form, then you need to provide it to them. In EHR systems, we understand that many times within the electronic medical record, there are links to other data or lab results or images. And HIPAA has said that if that's the case in your EHR, you need to also be incorporating those links and additional data in the copy that you hand over to the individual. So how the heck do you do this? Well, an individual might come to you and say, I have this thumb drive, can you put it in your computer and get my info? And that's likely not what you're going to want to do. It's probably not going to be a good idea. It's going to be risky to the system to let everybody insert their flash drives into your system. But You can't make them to buy a thumb drive from you, but you need to give them electronic access, so you need to find an alternative way to give that to them. We suggest sending emails. Encrypted emails are best. HIPAA said you actually can send an unencrypted email if you advise that individual of the risk and they still agree to it, but we would caution you to use encrypted emails. And I think in a conference that Breyer went to on this, on the new rules, OCR had said that PDF files are probably the easiest and most accessible and common method of providing electronic access. Another piece that's changed in the individual access portion of the world is actually just a regulation that's confirming a practice that's been going on for a while, which is individual comes to you, you're the covered entity, and you have to transmit a copy of, and they ask you to transmit a copy of their PHI to a third party. Well, that's actually now part of the rule, and there are a couple specific requirements about it. The first is that you have to they have to request that you provide that PHI in writing, and they have to sign the request, and then they have to say specifically on the request where to send that copy of the PHI. So another piece of documentation that's coming in play here. I think the easiest way to incorporate this new documentation requirement is to make it part of your what's for access form. And I have an example of a request for access form. This is in our standard policies and procedures, our templates. Basically about half to two-thirds of the way down, you can see a section where we've said, well, let me back up. This is the form that when someone walks up to the desk and says, I want a copy of my PHI, you would have them fill it out and explain what they want, etc. And then we've added a piece that says where the individual can request in the form that the PHI go to a third party. So that's one easy, quick way to incorporate that. And I will say that the requirement that you send PHI to a third party upon an individual's request applies whether you maintain PHI on paper or whether you have an electronic system. All right, I say a few words about how you can charge individuals for the work you do when you provide them a copy of their info. State law is going to be a huge piece here, so don't forget to consider that. Basically, the thing to know about state law here is that if Minnesota, for example, says you can charge 25 cents a page, but the cost that it costs you to provide the info is only 5 cents, you can't charge up to the 25 cents. You have to charge the 5 cents. So basically, the general rule is you may charge a reasonable cost-based fee. You can charge for the labor costs of copying the PHI. You can also charge for the supplies that you might require to provide the PHI, including whether it's the CD-ROM, if the patient has agreed that they want it on a thumb drive, the thumb drive. But remember, you can't require them to accept the electronic PHI in one form. You have to be open to the alternatives there. One thing that came through in the rules is that you cannot charge just like a flat $25 retrieval fee just for your trouble. That's not okay. All right, moving on to the next policy where you're going to want to make some changes. That's where an individual has an opportunity to restrict or to request that a covered entity restrict disclosures of their PHI. The general rule is that you don't have to, if you're a covered entity, you don't have to agree to restrict disclosures. It's sort of up to you if you're reasonable. But now there is one exception to that rule where the covered entity absolutely has to agree to restrict the disclosure. And that is where an individual has said, I don't want you to disclose information about this service you provided to me for payment or healthcare operations to my health plan. And the individual may pay in full for that item or service, and when they have done that, the covered entity is prohibited from disclosing that information to the health plan. There is an exception for when the covered entity is required by law to disclose. I would note that this is going to be an interesting issue because HMO contracts routinely say that you cannot charge a patient in full for covered services. The contract is not going to be enough to OCR. If it's the law, then you don't have to agree to the restriction, but the contract, you have to continue to agree to the restriction. The OCR's clever solution to this issue that will come up is, well, you have 180 days until September, at the time the rule came out, 180 days till September 23rd, 2013 to change your contracts with your insurers. So you could fix it that way. I don't think that's actually going to be fixed that way, but so that's a heads up on that front. You can't ask the patients to pay up front to make sure you get paid. The next few slides I'm going to go through relatively quickly because they don't necessarily apply to everybody. Not everybody does marketing, fundraising, sale of PHI. And I will say generally for marketing, sale, and fundraising, these are tricky areas of the regulations. They're confusing and they're complicated. And I would highly recommend having an attorney help you if you think you want to use PHI for marketing, fundraising, or if you want to sell it, because there are many places to go wrong. So tread carefully. So for marketing, if you have a policy on marketing, the general rule is the same, that you have to have an authorization from the individual if you're going to use PHI to market to them. And just for everybody, marketing is when you're communicating about a product or service and you're encouraging the individual to purchase or use that product or service. So that's kind of the realm of communications we're talking about. The thing to know about marketing is that certain things are not going to be considered marketing, and those are really going to input you in figuring out communications. As a general rule, you can make communications for the treatment purpose of an individual. If you're a healthcare provider, for example, you can talk to them about care coordination, you can recommend alternative treatments, therapies, etc. And that's not going to be considered marketing, which would require an authorization, unless the covered entity gets paid by somebody to make the communication. So, example, device company pays you to make a communication about a device and tell somebody why they should use it. That's going to be marketing, and you're going to need an authorization. A couple of other things are also never marketing or requiring an authorization. First is face-to-face communications. You can give promotional gifts that are of nominal value. You can also do refill reminders, even if a pharmaceutical company is paying you, so long as they're just paying you a reasonable amount related to the cost. So if you do have a marketing communication, your authorization absolutely, and that marketing communication, you're paid for that, then your authorization absolutely has to say that you're getting paid for it. So if you do a lot of these subsidized communications, you might want to have a general authorization that says, hey, I'm okay with covered entity getting paid generally for making marketing communications. Again, talk to your lawyer about how to craft that. Fundraising is a little bit simpler. Basically, fundraising is when the covered entity or their foundation or a business associate is trying to raise funds for, let's say, the hospital in an example, and they want to contact former patients or families in order to raise money. And so the rule now is that you can use a number of pieces of information and make those communications for fundraising purposes without getting the individual's authorization. So I've listed those 6 or 7 items that you can use on the slide. Even if you do use those items and you don't get an authorization, you absolutely still have to provide the individual with an opportunity to opt out of future fundraising communications. So you can make the communication over the phone. But you can say, look, if you don't want to get these kinds of phone calls anymore, here's what you need to do to opt out. And you can't make them through too many hoops to opt out. It has to be pretty easy. All right, selling PHI, I think this is really a risky area, not just because of HIPAA, but because of state laws, consumer protection laws, and how this is viewed. Basically, the new rule, general rule, is that you have to have an authorization from the individual before you sell their PHI. And basically, a sale is where you get any kind of remuneration, whether it's in kind or cash, in exchange for PHI to provide. There are a number of things that are not considered sales that will probably be helpful to you. I'm not going to go through those one by one, but they're over the next few slides. Certainly contact us if you have questions about these specifics. And I'm going to keep moving through so we stay on task. All right. One area that changed was PHI of decedents. So now the rule is that basically once an individual is deceased, their PHI is protected under HIPAA until 50 years after the date of their death. After that time, then OCR has said that that information is no longer PHI, so it's not protected. So interesting, there's still state law issues to consider, professional ethics issues to consider, but that's the HIPAA rule on it. The other sort of leeway that HIPAA has given in the new regs is that they've said A covered entity can disclose info about a deceased individual to a family member or somebody who is involved in that person's care or might be involved in the payment for the care prior to their death, if it's relevant to that individual, unless you know that doing so would have been inconsistent with what that individual would have wanted. And then very quickly, I will talk about student immunizations. There's some more leeway here that the new regs have provided, basically saying now that a covered entity doesn't need to have a written authorization in order to provide proof of immunization to schools about minors. You do have to obtain and document agreement to that disclosure from the minor's parents, and so make sure that when you're getting that agreement, you're documenting it so that you can show it was provided. I'm going to turn it over to Briar to talk about the exciting issue of breach notification.
Right, and this is another thing that you hope that you never have to deal with, but it is important to have a policy for breach notification in case something goes wrong. The new regulations did make a revision to the rule, but it's really not a huge change in practice. The rule now says that a breach of PHI is the acquisition, access, use, or disclosure of unsecured PHI, and basically that is PHI that's not encrypted or otherwise destroyed. So unsecured PHI, if it's not permitted by the privacy rule and it compromises the security or privacy of the PHI. The former standard was whether the use or disclosure posed a significant risk of financial, reputational, or other harm to the individual. And OCR determined that that was too vague of a standard, too subjective. So they changed it to this compromises the security or privacy of the PHI. The new regulations also got rid of a safe harbor related to information. If the safe harbor had said if all of these identifiers are removed, essentially if it was a limited data set that also didn't include date of birth and some other specific information, then it was automatically considered not a breach. They got rid of that safe harbor, but I think the result is going to still be the same in virtually every case. If the information that you're losing has hardly any identifiers on it, then the risk that it compromises the security or privacy of the PHI is going to be really low. So OCR has said any acquisition, use, or disclosure is presumed to be a breach unless the covered entity can demonstrate a low probability that the PHI has been compromised. And they made a big show about saying that this was an objective risk assessment, come up with this, but it still seems pretty subjective because you still do have to make a judgment about whether there is in fact a low probability, and that term is not defined. So when something happens, do your risk assessment, and they want to take these factors into account. These are specifically listed in the rule and should be included in your policy. The nature and extent of the PHI involved, including the types of identifiers and the likelihood of re-identification, and things like social security number, detailed information about treatment, that kind of thing is the type of identifier that would make it a high probability that PHI has been compromised. An unauthorized person who used the unauthorized person who used the PHI or to whom the disclosure was made. That kind of gets to, if your clinic sends something, faxes something to a clinic instead to a patient, and the receiving clinic says, oh, got this, we immediately put it into the shredder. We knew it wasn't for us. That seems, and a covered entity has its own obligations to keep stuff private, so that seems like that's probably not a huge risk. If you accidentally fax something to the newspaper, which did happen with one of our clients, that maybe is a more significant problem. Whether the PHI was actually acquired or viewed, and again, that's, if you have your files out there blowing through the wind on the prairie and end up in a barbed wire fence, which also happened to a client, but your clinic administrator went out there and gathered up the documents and shredded them, the PHI probably wasn't acquired or viewed, and that's going to be a low probability. And then the extent to which the risk to the PHI has been mitigated, and that will depend, that is very fact specific and will depend on what you have been able to do to make sure that there is a low probability of that PHI going where it's not supposed to go or being viewed by anybody who's not supposed to view it. If there is a low probability that the PHI has been compromised, then it's not going to be a breach, and you should document that assessment, document your full risk assessment, and document your conclusion, and make sure it's something that you could defend if OCR came to ask about it. Mitigate it and correct it going forward. So if your stuff was blowing into the barbed wire fence, maybe next time tie it down and make sure that it's not going to blow away. If there's a breach, then follow the notification procedures. And there were really not changes to the breach notification rules on notification. But what you need to do is notify the patient or patients by letter, notify the media if the breach affected more than 500 people in one city, state, or county, and notify OCR. If you have more than 500 people affected, you have to notify OCR at the same time that you notify the individuals. And if you have fewer than 500, then you notify OCR in a yearly submission on their website. They've got a link where you can fill in all the information. Business associates. Another change in the rule was for business associates, and essentially the main rules with business associates are still the same, but there are some new definitions. They are explicitly, all the security rule provisions explicitly now apply to business associates. Some of the privacy rule provisions apply, but not all. And there is now direct liability for business associates for failing to comply. This, by the way, is one of the new slides that should be in your packet. So, who is a business associate? These next slides cover it, and the definition to who is a business associate has changed, so update your policies with that. But in practice, most of the people anybody who used to be a business associate is still going to be one, and maybe you'll have a few that said that they weren't before, that now you should say, oh, yes, you are. So it's a person or entity maintaining on behalf of the covered entity, or creating, receiving, maintaining, or transmitting PHI for a function or activity regulated by HIPAA. And then the whole list of stuff, utilization, quality assurance, blah, 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 blah. The maintain or transmit is in bold because that is new. So if somebody is transmitting PHI for you or maintaining it, like, for example, an EHR company, a company that has your PHI up there in the cloud somewhere, they're maintaining it on your behalf, and they are a business associate even if they want to fight about that. More who is a business associate if they're providing these services to you. And keep in mind that it has to involve the disclosure of PHI. So if somebody is providing you with legal services, but they're your real estate lawyer and they have no need to get PHI, they're not a business associate. A health information organization, prescribing gateway, those also specifically considered business associates. Somebody offering a personal health record to one or more individuals on behalf of the covered entity, or a subcontractor that creates, receives, maintains, or transmits PHI on behalf of the business associate. So I know we do have some business associates on the line, and keep in mind, business associates, anybody that's a subcontractor for you that is doing any of those things with PHI is your business associate, and you need to have a business associate agreement with them. Here are the privacy rule provisions that apply directly to I say BAs, they apply directly to business associates and should be part of the business associate agreement. Uses and disclosures of P done only as business associate agreement or required by law. Business associates have to disclose PHI to the secretary to determine the business associate's compliance with HIPAA. And business associates have to provide access to a covered entity or to an individual to satisfy the covered entity's obligations on access, and Katie talked about what those obligations are. More of what applies directly to business associates, the minimum necessary provisions, so business associates can only use, disclose, request what is necessary to accomplish the purpose of the use, disclosure, or request. So be cautious about business associates requesting the full medical record unless they need it. And that holds especially true when you are submitting stuff electronically to a business associate. You don't want to give them access to your full electronic record if they only need financial pieces of information, for example. Have business associate agreements with subcontractors that include the same obligations that the business associate has with a covered entity. And one thing that's a little bit tough for business associates is covered entities will come to you with 800 different business associate agreements with slightly different terms in all of them. So you want to make sure that you're not agreeing to anything in those agreements with covered entities that you don't also have with your subcontractors. And that is going to be a moving target and is difficult. And covered entities mostly are not going to pay much attention when you say, well, but we don't have that with our subcontractors. The covered entity would say, well, that's our rule, so take it or leave it. If a business associate or subcontractor knows of a pattern or activity or a practice that is a material breach or violation of the obligations that they have, the business associate has to cure the breach or end the violation or terminate the contract. And that is something that a covered entity has to do with its business associates, and that now also directly applies to business associates. So when you're dealing with business associate agreements and your policy, make sure that there is a person or a department that's in charge of business associate agreements that has to deal with negotiating them when necessary, that deals with getting them executed and making sure that they're executed on the other side, and that maintains the documents either electronically or in paper form. You want to be able to show to OCR, if they ask, that you do in fact have a business associate agreement with X business associate. Keep a log of all of those agreements. One thing to do now is review the relationships that you have in place and make sure that you've got the business associate agreements where there is supposed to be one. If they have been long-term business associate agreements, then you can take your time to update them over the course of the next year. And one important thing, get indemnification from your business associates when possible. And this is, I think, when we're negotiating business associate agreements, that is the biggest sticking point. And it is important. Sometimes business associates will say, yeah, we don't indemnify at all. And to me, that's not really appropriate, because the covered entity does not have control over what the business associate does, and it can be stuck with a huge bill for dealing with costs related to a business associate's failure. So, for example, with a lost laptop, the covered entity might be on the hook for full forensic investigation and dealing with notification of hundreds or thousands of patients. At the very, very least, you want to get indemnified for costs of notifying patients and then any fines that would result from the business associate's failure. But that often is a battle, and it's just one that gets annoying to fight about, but it is, in my opinion, worth it.
And sometimes people agree, they don't like the word indemnify, but they will agree to reimburse up to a certain amount.
True.
When it's practically the same thing for our purposes, but try different adjectives and verbs. And
we'll talk a little bit about changed forms, too, and I believe Katie is going to take care of that.
Yes. So, just generally, there's a list of forms at the end of the slides that had various forms that we suggest having. Actually, the first that we were going to talk about is the business associate agreement. But I will say this. You need to have a business associate agreement. You need to have a notice of privacy practices. You need to have authorizations. Those are the three forms that are required. The other forms, request for amendment, request for access, those aren't necessarily required, but I think they're just useful to have in your operations and keeping documentation of your compliance.
So the form business associate agreement, you should pay more attention to subcontractors in this document. Business associates have to take reasonable steps if they know that the subcontractor is not complying, and that should be in the document. It should say business associate will require these things, including notification. And again, covered entities have had this responsibility with respect to their business associates. And so we see a number of business associate agreements that come through where a covered entity says, we will audit the business associate to make sure that they're complying. That is not required by HIPAA, and I don't particularly recommend that, partially because I don't think most covered entities will ever do that. And for business associates, I would say, well, you don't want to have a covered entity come poking its nose into your business particularly. Just make sure you're doing what you're supposed to do. But if you're a covered entity and you know for a fact that your business associate is screwing something up, you do have an obligation to take care of that. In your business associate agreement, you should have a notation that the business associate must comply with security rule provisions and that they must report breaches and any other improper uses and disclosures of PHI to the covered entity. The report of breaches, one thing that we negotiate from time to time is how quickly those things have to be reported. And I've seen anything from 24 hours, which seems a little extreme, to 60 days, which is unacceptable. The covered entity has its own obligations to deal with breaches in a short time period, and 60 days is the outside end of that. So if your business associate is only telling you about something on the 60th day, you are totally hamstrung and you can't do what you need to do. So make sure, I would say a reasonable period is anywhere from probably 2 to 10 days, but the shorter the better for purposes of the covered entity. Your business associate agreement should also describe, to the extent that a business associate carries out a covered entity's obligations under HIPAA, the business associate has to comply with the HIPAA requirements that would apply to the covered entity when they're performing that obligation. So ask yourself, if the business associate is contracted to perform a required HIPAA provision, then you have to say that they have to do it in the way that the covered entity would do it. That doesn't happen in a ton of cases. Business associates don't usually take over those responsibilities for a covered entity, so that's not likely to be a huge deal, but it is something that should go in your business associate agreement. These things are not required. Indemnification's not required by HIPAA, but again, very, very seriously recommend that you get that. Specific short reporting periods, instead of just saying we'll promptly report. Data aggregation is not required to be in a business associate agreement, but if your business associate is going to be doing data aggregation for the covered entity, you need to include that. Similarly, de-identification, business associates will sometimes specifically want that in there. You don't have to give them the right to be able to de-identify information. Sometimes the business associate will want to be able to do that so that they can then take that de-identified information and use it for their own internal marketing purposes or whatever. Once it's de-identified, it is not considered protected health information, so it's not a problem if they do that, but some covered entities are not comfortable with that anyway. If they're going to de-identify, you want to make sure that they de-identify in compliance with the privacy rule, which deals with re-identification and other things like that.
All right, so I've been referring to this authorization form throughout. Actually included a screenshot of what our draft form that we provide in the policies that we sell. This is exactly what the authorization looks like. It's been updated with all the new bells and whistles on where you would insert new statements based on the new regs, and I'll quickly go through what those might be. If you are using your authorization to get the individual to consent to use of their PHI for marketing purposes and you're getting paid for it, the authorization absolutely has to have a statement that says you're getting paid for it. If you're selling it, if you're selling the PHI, the authorization has to say that the covered entity is going to get money for that and that it's a sale. Remember that the sale provisions apply to whether you get cash or, equipment or new computer system or something in kind for the PHI that you're selling. There are a number of complicated new rules about when you may not use a compound authorization. So when you can put two authorizations, research and marketing into one document. I'm not going to go into those. We have our February 2013 webinar where we talked about that in detail. You can also call us and we can talk about that. These are kind of tricky, so I'd advise using counsel in drafting these. And as David said at the beginning, our February 2013 webinar is actually up on SlideShare for you to listen to and view. Notice of privacy practices is another form that all covered entities have to have. Business associates do not have to have them. Just generally about notice of privacy practices. I see this all the time. Notices do not incorporate state law, but HIPAA requires you to incorporate state law in your notice. And actually a question came through, can you help us with state law? Well, we can't help you with state law on this webinar because we have people from, like Briar said, all different time zones on this webinar. But yes, if you can, we can help you with state law. We can help you update the notice of privacy practices to reflect that. So don't hesitate to contact us for that. The other thing that has been a rule for quite some time is that if you're a covered entity, you have to post your notice of privacy practice on your website. You'd be amazed how many people don't actually do this. So post the whole notice on the website, not just a summary. It's one of the easy ways for OCR to go and see if you're in compliance. Just go to your website. If they can't find your notice, then there's one thing that they can take issue with. Also, the notice of privacy practice is not a substitute for getting an authorization. So just because somebody has signed a receipt that says, yes, I got the notice of privacy practice, which you do probably with all of your patients, that doesn't mean that you don't later have to get authorization for disclosures that aren't otherwise permitted. I've actually gone through bullet by bullet with what needs to change in your notice of privacy practices. So these are hopefully pretty easy to follow, and I'm not going to go through them one by one because we want to get to questions and I want to get to Briar's important topic of security risk assessment. The other thing about notice of privacy practice, you can also remove the statement that that you can contact them for appointment reminders or information and alternatives to health-related benefits, because now if you're doing marketing, then that has to be in the notice of privacy practices.
So I could probably limit the security risk assessment slide to just this first bullet point, which is do this. please do a security risk assessment. This is something that OCR is looking for every time that there is a violation. Now, we are seeing they will ask for a risk assessment, an updated risk assessment, copies of your ongoing risk assessments. They want to see that you're paying attention to where the risks are in your organization and where your PHI is and how it might be accessed inappropriately. The meaningful use risk assessment can be helpful if you're part of the meaningful use program. That also requires a risk assessment, and that can be good. But one important thing is it is not a one-size-fits-all thing. So in our policies that we offer to, that Katie had mentioned before, there is a big section on the security rule, and it includes provisions related to the risk assessment. But it's impossible for us to give you a security risk assessment. It is something that you actually have to do. You can follow along with what the policies say, but there are multiple places where you need to fill in, here's where our risks are, here's what we've looked at, here's what we've done to fix it. OCR has also produced a series of papers on how to conduct a risk assessment and how to move towards security rule compliance. These are just 3 of the sites that you can go to. But if you poke around even a little bit on the OCR website and the security rule provisions, you can find a lot of guidance and a lot of, even though it's not the law that you have to do certain things, it shows you what OCR is looking at and what they are sort of expecting you to do. So it is useful, it's helpful, and please do that because that is where we are seeing a ton of problems and where, for example, that $1.5 million fine came from. You can do the risk analysis yourself. You will need somebody to give you assistance that has some security knowledge or IT expertise. We would be lost, of course, without our IT people who are sitting here helping us not ruin everything. And they're going to know where is your information going, who could get access to it, what do you need to do. You can also work with outsiders. You can hire vendors to assist you with your security rule assessment. Get a business associate agreement in place with any outsiders that you have doing this. Determine what your vulnerabilities are and then fix them. If you give OCR a risk assessment that identifies risks and then does not show a plan for or a concluded fix on the problem, that is going to be a subject of much discussion with them.
Briar just got a question actually related to security rule risk assessment. How often is it reasonable to do one?
If you haven't done one, then do one immediately. And after that, it depends on, you could do one every time you get some new kind of piece of equipment, some new system. Anytime that you have an identified problem, kind of do a mini follow-up security risk assessment. There's no specific requirement for how often that they have to be done, but the process is supposed to be ongoing. So you can't just do it one time and then put it in the shelf and forget about it.
All right, so just want to briefly talk about some of the things that we see as plaguing many of our clients. Snooping employees is by far, at least in my experience, the biggest issue that has turned into OCR investigations. So it seems like something that you should be able to control, but I feel like, I don't know if it's people don't train or people don't pay attention to the training. You have ex-spouse situations, snooping neighbor situations. They're getting into the medical record at work. They're finding things out. They're telling the other neighbor, and then the patient gets upset. The patient complains, and then you have to discipline the snooping employee. And the reason this has led to a lot of OCR investigations is because the patient will also want to complain to OCR. And even though OCR is, I think, pretty overloaded, it seems like they've elevated the snooping employee complaints to the top, because in 2 instances that I can think of, the patients made a complaint and couldn't have been more than 30 days after that the organization got a letter from OCR. So it's really important to train your workforce and help them understand how bad it is to be snooping in medical records.
And part of the way that you can demonstrate how bad it is to take serious disciplinary action when somebody screws it up. That doesn't always mean firing the person, but it can't just be a note in the file that says you can't do this. Lost laptops are a huge issue. Lost hard drives, flash drives. That is a major, major problem and has a pretty easy fix in that if you encrypt these things, then you are really protecting yourself. So please encrypt. In most cases, it's not that expensive to do it anymore, and it's highly recommended. Similarly, as mentioned, the failure to do the security rule risk assessment, please do it. Katie mentioned the failure to have a full set of policies is a problem. Not having required documentation, same as the policies. They're going to ask you for your training logs. They're going to ask you for business associate agreements. You should have something to show them.
Yeah, we've seen a lot of letters, faxes sent to the wrong people. There's appear to be some sort of mail merge malfunctions where a letter will be sent for the purpose of, for example, providing info on diabetes treatment, but the wrong patient list will be used. And so all of a sudden we've sent info to someone that isn't theirs and might be potentially problematic for other people to have had disclosed. So that's another place to be careful.
So we've got millions of questions,
Yes.
which I think means that we have just done a perfect job of
Yes.
explaining this.
I think, and in our hurry here, I think I've handed you the batch of
Do I have
questions
all
that
of
I was
them?
going to answer, and here's some that maybe you can answer.
Excellent.
But let's see here. Excuse
Okay,
us while we-
one is if you can charge for labor to fulfill a request for access to PHI, can the labor costs include the labor cost to retrieve the PHI? And yes, it can. It just can't be where we automatically set a $25 amount for that. You're actually supposed to calculate the actual cost to the organization for that labor.
Here's a question about marketing. When a facility sends notices of an educational event promoting a new treatment or procedure uses its database for the names and address, is this marketing for which you need an authorization? So this depends on whether you're getting paid to do it. If you're just making the communication for treatment purposes and it's by a healthcare provider and you're not getting paid to make that communication by some third party, then that's not going to require an authorization. But if it is subsidized, then that would require an authorization.
One is about cleaning people. We know they're not required, they're not business associates, but is a signed form that says they will maintain privacy enough. We have an EHR, but still have paper reports not scanned in on desks, and I worry about this. It's good to be worried, but I would say that yes, probably a signed form that says they will maintain privacy is good enough. They are not supposed to be looking at PHI, and I think that it's not part of their job to do their cleaning services. So you could say in a very simple one-page document, I agree that I will not look at anything, I will not review any papers, I will maintain confidentiality of anything I see accidentally, signed this person, and if it doesn't happen like that, then consequences.
I have a similar question on that, but this person had asked, do we need a BA even though our BA doesn't, or the person doesn't have computer access? So I guess the important point there being a business associate doesn't just use electronic PHI, they may also use hard copy PHI. So remember that that's broader.
Does a covered entity have to get a business associate agreement with a bank when the covered entity is the payee for a client? They do not.
Nope, that's specifically accepted, right?
Yep.
Banks are. Similar, let's see, is UPS a business associate because they transmit information? And actually, that's a really good question. In the commentary, OCR said that certain courier services and like UPS and then also internet service providers would be excluded even though they are transmitting PHI on behalf of the covered entity.
Right, there's a weird analysis of how transient is the information.
The conduit exception or
Right.
something like that.
Business associates, when we send our BAA to them, they typically don't want to sign ours, but want us to sign their BAA. How do you deal with this? Should we insist that they sign ours, and do we sign theirs? You shouldn't sign both of them. You should just sign one. And this is a very common problem. Generally, I say, listen, we're the covered entity, and so you need to sign ours. If they insist that they won't, then you can review what they have in their business associate agreement and work with them to make sure that it addresses everything that you need it to address, which I would say, again, include indemnification and include short reporting periods and that kind of thing. But basically, if it's in compliance with the law, it doesn't really matter whose form it is.
And before we move, we'll stay on for a couple more questions, but I just wanted to say that the policies and procedures, the updated notice of privacy practices, and the Temple Business Associate that is updated and has all the bells and whistles, that is available on our website, on our web store, and we have the link on this slide. The policies alone are $300. They're very comprehensive. I think it's a really good deal. The notice of privacy practice is $100. For state law purposes, we have 3 states that we've done full sets for: Wisconsin, Minnesota, and Iowa. We can do more state law analysis, so if your state's not on there, call us and we'll work it out. Also, the business associate agreement is free, and it's wonderful, and you can use it when you're negotiating these contracts. So download it and more power to you in negotiations.
And again, one caution with the policies, although they are comprehensive, they do absolutely require you to go through and figure out what your organization actually does and appropriately reflect that in the policies. And that's particularly true with the security rule stuff, so don't just buy it and put it in a binder.
This is a question about when the clock starts running for notification of breaches. When does the covered entity's 60-day time period to notify begin to run? Is it when the covered entity knows about the breach or should know about it? It actually is when the covered entity should have known about the breach based on reasonable due diligence procedures. Raises an interesting question about when the business associate is the source of the breach and the business associate doesn't find out. Should the covered entity have known about it? And that gets into a sort of a global question about how much regulation do you put on your business associates. I don't think there's a clear answer, but as much as possible.
Right. And
might not be practical.
And there is kind of a complicated analysis about whether the business associate is your agent. If they're your agent, then you're deemed to know about it when they know about it. So the sooner the better, basically, and have them notify you so that you don't have to worry about it. One question, are you recommending that we delete out the fundraising and research policies if we do not do either one? And either way is fine. You could delete them or you could keep them in. If you want to streamline and you know that you're not going to be doing those things, then I would say, yes, go ahead and get rid of the forms. But you could also keep them and note that they're not currently used or not currently applicable.
Here's a question about authorizations. Is a patient authorization necessary to request a second opinion and information is sent to a third party for that purpose? So example, pathology reports slide sent to an outside pathologist for a second opinion. So the core principle about authorization is actually goes back to what you can do under HIPAA. So a covered entity can disclose for treatment, payment, or healthcare operations without an authorization under HIPAA. So this example would be a treatment purpose. I didn't say this because I was going through it pretty quickly, but authorizations are used for disclosures that are not treatment, payment, or healthcare operations. And most commonly, they're used for research, marketing, fundraising, sale, other sort of random disclosures under HIPAA.
Another BAA question, do we need a mutual BAA with the EHR company, or is their contract good as long as it's updated? I'm not sure if that means it's a business associate from the EHR company. Generally, EHR providers will have sometimes they will have business associate provisions in their agreement. Sometimes they'll have a separate business associate agreement. Sometimes they wait for you to give them yours. If there is a business associate agreement or business associate provisions from the EHR company and they meet the criteria, the new criteria, and the provisions are acceptable to you as a covered entity, then that's fine. You can go ahead and use theirs. If you're concerned about it, give them a copy of yours and ask them to deal with that.
Question about charging for record retrieval. I interpret HIPAA restriction on charging to apply to record requests from patients or their personal representatives. Let's see. Requests from law firms and litigation management companies, for example, could be charged a search fee. So this is kind of interesting because can you charge a retrieval fee to a litigation management company? I think that it depends on who the request is from. If the request is technically from the patient for the covered entity to provide the copy to the litigation or the law firm, then that would be a retrieval fee that could not be charged for the patient to access. But if it's separate from the patient's request, then I think the HIPAA doesn't talk about that.
I think that's right. Administrative things, some of the business associate slides are not in the PowerPoint. Will there be an update? It should be in the current version, the updated version of the PowerPoint. If you did it before this morning, there were a couple slides that were not in there, so should be able to just use the updated version.
And that's going to be available in the next few days on SlideShare, and you will get an email from our wonderful IT people and marketing people directing you directly to SlideShare and telling you how to use it after this webinar. Just a request to go over the costs of the policies again. I'll probably move through that too quickly. The policies include, actually, if you go back a number of slides to the screenshots of the policies, that is what is included in our template policies for sale. So it's privacy rule policies and security rule policies. The set of policies for both rules is $300. The notice of privacy practice is $100, and the business associate is free. Question again about marketing. Can a business associate or covered entity perform business analytics on PHI to develop a general marketing strategy? Example, how to attract more patients to the covered entity's clinic. They would not be selling the product directly to the patients. So this, I think, using PHI to develop sort of a marketing strategy, I think I would try to fit that under healthcare operations, which would be permissible. I think it's kind of a fine line. If you're using that info to eventually make a specific communication, I think it falls on the side of marketing. However, if it is about treatment or alternative therapies, then that would be meeting the exception, and you could make that communication without getting an authorization.
I think this will probably be our last question here, and then for those of you that ask questions that we haven't had time to get to, Katie and I will follow up afterwards. How much oversight of business associate compliance activities is a covered entity supposed to maintain? Some have taken the stance that covered entities are now required to keep records of business associate training of its staff, its policies and procedures, etc. What level of oversight of a business associate is actually required? Really not much. Really, it is only if you know of a pattern or practice of activity that is not permitted, that is the only level of oversight you're required to have. In some cases, if a business associate is doing tons of stuff involving a lot of PHI or highly sensitive PHI, it might make sense to get some more, to put in place some more oversight. Again, it's not specifically required, but probably a good idea from a risk management perspective to say, okay, show me your policies, show me that you do this encryption, show me that you've done a security rule analysis, even give me your security rule risk assessment so I can take a look at it. And that is just to give you a level of comfort with who you're sharing your information with. But you're not required to do that. So it's certainly not wrong to say you want to see records of the business associate's training, you want to see its policies and procedures. Some business associates will say, forget that, we're not sharing that, that's internal information. And then you can decide if you want to keep working with them. But you don't have to go in and poke around and see exactly what they're doing with your PHI.
And we will get back to a few more of you afterwards. Again, visit our SlideShare site per the email you get afterwards. Visit our web store, contact, email, call us, and we hope to see you or your colleagues on the August 14th webinar on pricing. And also one more note, make sure to take the survey. We want your ideas about what to talk about because that makes it all the more interesting. Thank you again.